Documents feature quite prominently on bar exam essays involving evidence. Questions involving documents don't come up as often on the multi-state. Here, what we're concerned about are writings. And typically, there's a cluster of issues that come up around writings. We're not going to cover all of them in great depth here. The basic approach to any item of evidence is, first, to establish its logical relevance. But with a writing, we also have to consider issues that are common to real evidence. In particular, we have to establish the authenticity of the document. So, authentication is an important problem here. Also, sometimes we have to deal with issues of hearsay, and we have to deal with the best evidence rule and privileges. For our purposes in this presentation, we're going to focus our attention on authentication and the best evidence rule. And there are a couple of other issues that arise with regard to documents that we will touch on now. The other issues we will consider later when we touch on hearsay and privilege. So, first, we have to consider authentication. And authenticating a document is strikingly similar to authenticating any other tangible item. There are a number of ways that a document can be authenticated. The parties can agree to stipulate that a document is what they agree it is. One party can admit that a document is what the other party says it is. We can also authenticate documents by eyewitness testimony, and it is not uncommon for the multi-state to ask questions about handwriting authentication. And here we've got a fairly typical little rule. Anybody who is personally familiar with the handwriting at issue can testify as to its authenticity, no matter how old that familiarity is. So we can have someone who was familiar with the handwriting of the person 45 years ago and hasn't seen it for 45 years, and that person can come to court and authenticate handwriting. Now, what the jury chooses to believe about that authentication is up to them. Now compare that to a situation where we've got someone who is unfamiliar with the handwriting of the person that is at issue. Unless that person is an expert, that person can't authenticate handwriting. One other issue that's commonly tested deals with ancient documents. We define ancient as older than 20 years under the federal rules. Finally, authentication issues common to photographs also arise in documentary evidence. And remember, photographs are admissible upon testimony that the photograph depicts the location or event at issue. And really, any witness with personal knowledge can testify. Next, we turn to the best evidence rule. The best evidence rule is fairly commonly tested on the multi-state, although not heavily tested, and it's also very commonly tested on essays. The Federal Rules of Evidence sets forth the requirements for an original in Rule 1002, and it indicates that to prove the content of a writing, recording, or photograph, the original writing, recording, or photograph is required, except as provided by the rules or an act of Congress. So there are a number of situations in which the best evidence rule applies, and none of them are terribly complicated. First, we need to keep in mind that the best evidence rule applies to the proof of the contents of a document. It doesn't apply to the proof of the existence of a document. So this most frequently arises with regard to contracts, wills, or deeds, or other documents that have some operative legal effect. And here, the policy of the rule in providing the trier of fact with the exact language used is most important. So, we're concerned about the best evidence rule when we are trying to prove up the contents of a document, not when we are trying to prove that a document exists. Also, it's worth keeping in mind that the best evidence rule does not apply to records of events when the record is not used to prove the event. Although the best evidence rule does not apply to physical objects, it does apply to more than just conventional writings. Under the Federal Rules of Evidence, the best evidence rule applies to writings and recordings consisting of letters, words, or numbers or their equivalent, set down by handwriting, typewriting, printing, photostatting, photographing, magnetic impulse, mechanical or electronic recording, or other form of data compilation. So, photographs, which would include a regular still picture, or an X-ray, or a videotape, or a movie, also are considered covered by the best evidence rule. The best evidence rule is complicated by a comparatively recent concept known as duplicates. The federal rules of evidence consider a duplicate to be admissible exactly in the same way as an original, except when there is some genuine question about the authenticity of the document. So we have to confront the issue of what is a duplicate. And the essential idea is that a duplicate is an identical copy. It looks the same, it has the identical contents. It is not a handwritten copy of some other document. There are some circumstances in which the original copy of a document isn't available, and there aren't any duplicates available either. So the next question that arises is, how can we obtain admissible evidence to prove the contents of a document when we don't have the document? It's worth keeping in mind that the best evidence rule is a rule of preference. As long as it has been shown that there was in fact a genuine original, then secondary evidence of its contents is permissible under certain circumstances. For example, when the original is in the hands of a party opponent and notice to produce it has been given the opponent, then secondary evidence can be admitted if the party opponent refuses to produce the original. Similarly, where the original is unobtainable because it's in the possession of some third party who won't accept summons, then secondary evidence gets to come in. It seems to me that this is intuitively sensible. Again, similarly, if the original is lost or destroyed, and a diligent search has been made to find it, secondary evidence is admissible, again, within the discretion of the trial judge. The judge has to be satisfied that the search for the original was a diligent search. It's worth making note that the best evidence rule and issues related to it often touch on the function of the judge and the jury. The judge usually decides issues related to the best evidence rule. So questions relating to the admissibility of evidence under the best evidence rule, such as whether the contents of the document are to be proved, whether the document is collateral, or what is sufficient excuse for non-production of the original, are preliminary questions of fact, and they are resolved by the judge, not the jury, even though the jury typically is the finder of fact. The jury is the group that's going to decide if the existence of the document itself is in dispute. And that concludes a very quick summary of the best evidence rule. This material is fairly commonly tested on the multi-state, though not in tremendous depth. And best evidence rule issues routinely arise on the essays as well. It's worth noting that some states have rules about best evidence that differ from the federal rules. The last issue of documentary evidence that I wish to touch on in this brief video is the parole evidence rule. Remember that the parole evidence rule is from contracts. This is where the law of contracts and the law of evidence touch one another. Remember that the parole evidence rule requires us to examine the contents of a contract and not to go beyond the four corners of that contract unless there's a good reason to do so. And that wraps up a quick discussion of documentary evidence. Remember, documentary evidence basically consists of authentication issues, which are strikingly similar to those that we examined with regard to real evidence, and the best evidence rule, a fairly technical but not hugely complicated part of the federal rules of evidence. Next, we're going to consider what many of us think of to be the heart of evidence, testimonial evidence.